Welcome, friends, to the English version of our weekly program Para Ser Legal to Be Legal. Today, we're continuing our conversation with the public charge. Thank you for your questions and comments. The first thing we're going to talk about is, hey, are you subject to the public charge if you're going to consular process? And that came from questions from one of you. So thank you very much.
Calificas para ser legal, quieres saber, solo llama al abogado Andrés Mejer.
Welcome to Para Ser Legal to Be Legal, and today we're continuing our conversation of the public charge. First and foremost, our question from one of you: are you subject to the public charge if you consular process? What's consular process? Well, consular process, I'm glad you asked. Consular process is when you're applying for your green card, in this case, outside of the United States. So the most obvious example is someone entered I went to the US, I went on vacation, and I found my soulmate. I come back and I want to apply for her. She's gonna be interviewed outside the United States because she's not in the US. Or if she came into the United States, but she came without permission, she can't what's called adjust her status. She can't get interviewed in the US in order to receive her green card. She's gonna have to leave and be interviewed outside the United States, and that by a process called consular process. So today, everyone is now subject to the public charge rule, unless you're exempted. If you're seeking a green card, no matter if you file for adjustment of status, which is interview in the United States, or consular process, interview outside of the United States. Either way, you have to deal with the public charge. Now, the Department of State, so if you're consular process, you're going to the US Embassy or consulate in the country, usually the country where you're born. Now, the embassy is under the Department of State. Immigration is USCIS. So the Department of State came up with their own rules and their own questionnaire. It's Form DS 5540. Now, the Department of State rule generally follows the same new provisions that were announced by the Department of Homeland Security. The only difference is DHS gives you a 19-page form, and the Department of State, it's only a 4-page form. They still ask the same questions. They just jam it in so small it's hard to see. But, it doesn't look as intimidating when it's 4 pages. 19 is just, it's a beast. What happens if you've started the process, right? So your husband filed for you. Let's go back to the example that I just provided. I went abroad on vacation. I met my soulmate. I came back. I married her. I came back and I want to file for her. Well, I did it before the new rule changes because it takes about a year to get that approved nowadays. So at the time, I was not required to file the public charge documents. And guess what? I may not be required to do so. So if today you filed and the immigrant has not received an interview yet, I would suggest preparing it and taking it with you. It's better safe than sorry. You don't want to prepare it and give them ammunition that otherwise you might not need. But immigration in the Department of State is not supposed to deny the application without giving you opportunity to fill out the form. Because hey, when you started, though that requirement didn't exist, it only became a requirement after the fact. So they're not supposed to deny it without giving you that opportunity. But better safe than sorry. Collect the supporting documents, fill out the DS 5540, and take it with you, or give it to the immigrant, have the immigrant take it with her just in case. Number 2, how your family size and income or assets can make you a public charge. So listen, let's put this in context. Before February 24th, 2020, the standard was pretty straightforward. The question was, what was your family size, and did your sponsor have income that was 125% or more over the federal poverty guidelines? And the federal poverty guidelines are registered online. It's Form I-864P. It changes every year, but not too much. So it really was mostly income. And if income wasn't enough, then asset. So if your sponsor didn't have enough income, the question becomes, does she have sufficient assets? So what is the value of those assets? And it has to be 5 times the difference between the income she had and the income she needed to show. If that wasn't enough, then she needed a joint sponsor. Now, the joint sponsor often is a relative, parents in some cases, siblings, but it doesn't have to be. It could be anyone who's a U.S. citizen or lawful permanent resident. Doesn't have to be family, but maybe now it should be. With the changes, family is more likely to help each other with the new requirements. So they're looking at whether the person who's filing it actually will support you, actually will prevent you, keep you from filing for government benefits. Now, if it's a relative, they're more likely to do so. Food for thought, something to consider with your attorney before you file. Now, let me give you an example. Say Maria's a U.S. citizen. She's applying for her husband, George. They have one child together. So it's a household of 3. So the poverty guidelines is for a family of 3 is $21,720. Now they have to show 125% over the poverty guidelines, so that's $27,150. For each additional dependent that the family has, it's another $4,480. Let's round up and say $5,000. So if Maria needs to show income of $27,150, let's say she only makes $25,000. She doesn't work full time. So she needs to have assets that are 5 times the difference between $27,150, what she needs to show, and her actual income, $25,000. So that difference is $10,750. So the difference is $2,150 times 5 is $10,750. So she needs to show that she has assets over that amount. If she doesn't, she will need a joint sponsor. That's the process pre-February 24th, 2020. Under the new rules, the process becomes much more complicated and more subjective. The officer will now consider 7 factors to decide whether the immigrant will more likely than not become a public charge. For each factor, there are standards, which determines how the factor is to be assessed. If that sounds complicated, it's because it is, and it's done purposefully. So, what are the 7 factors? Age, we spoke about last time. Health, we're going to talk about here. Family status, we're talking about here. Assets, resources, and financial status, we're talking about right now. Education and skills, likely next week. Prospective immigration status and period of admission for non-immigrant visa. So that's not something you need to worry if you're applying for your green card. That's you're coming in as a student visa, you're coming as a J1 visa or an H1B, then you need to worry about that, but for now you don't. And the lastly is the affidavit of support, which we'll also likely talk about next week. So here's what DHS considers today to decide if you will be a public charge due to family size and income, right? So first, what is your family status? And what immigration really means is what's your household size? The rule expands household size to the immigrant spouse, the immigrant's children, either residing with the immigrant or if he is required to provide at least 50% of the child's financial support. Think child support obligations. And anyone other than the children for whom the immigrant must provide at least 50% of their individual support. So if you list a dependent on your income tax records, they will be part of your household. If you say you support them, then immigration will take you at your word and you will need to show sufficient income, which if you think about it is fair. If you're lying to the IRS to save money, it will cost you more in this context. But it is based off the number of dependents that you have when you file your income taxes. Second, so first is what's your family size? Second, how much income or assets do you need? So everybody in your household has to submit their most recent income tax records. Now, if it's your child, they're your dependent, they don't need to file income taxes. They're included in your process. So they're in your tax records. But anybody else in your household will need a tax transcript for the last year, and they'll ask what's the income for each of the last 3 years. You can also include legal income that's not included in tax returns as long as you can prove it. So legal income, maybe it's child support that you get, maybe it's a pension that you receive, maybe it's a settlement from a personal injury or workers' comp case, maybe it's an inheritance that you received after when your parents passed away and they left you some assets. So whatever it is, you just need to show it, you need to document it. So second is how much income or assets do you need? When do you have? Now, again, If your income is not enough, then immigration will evaluate your assets. As before, assets will need to be equal to or greater than 5 times the difference between your household income and the 125% over the poverty guidelines. So again, in the example we gave before with George and Maria, household of 3, you needed to show income of $27,150. So that was the minimum for a household of 3. If the income, Maria made $25,000, she didn't have enough, so she needs to show assets of 5 times the difference of those two numbers, which was $2,150 times 5 was $10,750. Now, what assets are sufficient? Checking and saving accounts, annuities, stocks and bonds, certificates of deposit, retirement and educational accounts. And if you own a home, you're going to need to have a recent licensed appraisal. So that's new. In the past, you didn't need that. You know, you could use an old appraisal, you could use a tax assessment, you can go to Twilio or Trulia and use that information, and that was sufficient. Now it's not. So for every checking account, annuity, or stock or account like that you have, you need to show the past 12 months of statements. That's a ton of documentation. So first, what's your household size? What's the income you need to show? And then do you have enough? If you have enough, you're done. If you don't have enough, you need assets. If you don't have enough, you're going to need a joint sponsor. Now, the third factor immigration is going to consider is, hey, do you have sufficient resources to cover any reasonably foreseeable medical costs? If you're perfectly healthy, they're not suggesting you need to have an extra $20,000 just in case you might get sick. What if Maria was disabled? What if she was epileptic, or she's schizophrenic, or she's bipolar, or I don't know, she has something that keeps her from ability to work, or sometimes because of the disease, she can't work regularly. Well, then they're asking, is there enough reasonable, resources to cover those reasonable, foreseeable medical costs? The focus is principally on working age household members. If they are sick, this affects their ability to earn money and contribute to the household. Anybody in your household with significant medical issues will be a negative factor unless there's health insurance to cover that. And fourth, what are your financial liabilities? In other words, what do you owe? Now you have to provide your credit score. Now, if you have any negative credit history, you're going to have to explain it. If you don't have a credit score, which is common for immigrants since they typically don't have a social security number, you just need to prove evidence of that. So provide a copy of your search and show the negative results. Fifth, whether the immigrant has applied for, been certified to receive, or receive public benefits. Now remember, this is before February 24th, 2020, shouldn't count. But you'll need to provide documentation from the agency that gave or certified that benefit. So look, they're just looking at if you ever filed for it, if you filed for it recently, well, that's an indication you may file for it in the future. If you make over 125% of the federal poverty guidelines, you're going to avoid this issue. If you don't, it's an admission that you can qualify for public benefits, and DHS is going to scrutinize the joint sponsor much more than they did in the past. Look, bottom line, it's not clear anymore. Now it's about how clearly you tell your story and how you present the positive and negative factors. A good attorney will make all the difference. They're even considering if you requested a fee waiver on any prior immigration application. That's a negative factor because it showed that you weren't making enough money. Now, if your income is over 250% over the federal poverty guidelines, or just double what you normally need, that is considered a highly positive factor in your favor. So what does that mean? Let's go back to George and Maria's example. Family household of 3, 120% poverty guidelines is $27,150. 250% or double that amount is $54,300. Now, what happens if your household is 5 people? Well, 125% over the federal poverty guideline is $38,350. Double that, or 250%, is $76,700. If you make that money, then again, does the household have that? If it does, then you're not likely to be a public charge. Now, let's look at whether your health will make you a public charge. Look, it isn't that the new rule has really changed the factors around health issues. It's just that the focus now is about the immigrant's ability to work and care for himself, to attend school or work. Serious medical conditions have always been a risk factor, but the government will systematically focus on it now. You've always had to, I wouldn't say always, but for at least the past 20 years, you've had to file G639 medical report with any green card application. This form is filled out by a civil surgeon in both the adjustment and consular process situations. Civil surgeon is just a doctor, but it's a doctor that's been certified to be able, that knows how to fill out this exam and knows what the government is looking for. It's not a new form. Now, the form is only valid for 18 months. So if you go see the civil surgeon and your application is filed within 60 days, it's good for 18 months. Otherwise, it's only good for a year. We typically file it, we tell you to go see the doctor only after you have your notice for your interview because things are taking so long. But now it changes. Now I'm going to recommend you get it right away because I want to know what the civil surgeon is going to say. Now listen, they're going to give you a sealed document. You have to present that sealed document to immigration, but that doesn't mean they can't give you a copy. Or that doesn't mean they can't give your attorney a copy to see, hey, is there a problem here? You know, before you leave the United States, we want to know if you're coming back. So in the past, we weren't really worried about it. Now, maybe we need to be worried about it. So if there's an issue, you'll need to fix it before your file. If you have a health issue, you need to have health insurance to cover it. This still won't address any time lost from work while you're receiving treatment, but at least it fixes the financial ability to pay for it. So the way to show this is that you've had this condition for some time. You show how it has affected you. You need to tell a story that will be self-sufficient. So how do you intend to do that without government assistance? So I have clients that, you know, they have kidney failure or they have kidney problems, they're on dialysis, and yet they still work. It's incredibly difficult to do. They're weak, they're tired, you know, but they do it anyway because they have to. Last subject today. What governmental benefits will cause you to be a public charge? All right. So the new rules punish receipt of vital health, housing, and nutritional programs, including federally funded Medicaid, there are exceptions, SNAP benefits, which used to be referred to as food stamps, and Section 8 housing benefits. So adding consideration of these benefits to the public charge analysis, however, has limited legal impact. Why? Because most immigrants who are on a path to a green card don't have access to these benefits. Hey, you don't qualify if you don't have a social, you don't have work authorization. You're not going to get it just because you necessarily need it. On the federal level, every state is different. So if you apply for state benefits, you could be disqualified. Now, if they do qualify, chances are they're in an immigrant category that is exempt from the public charge. Think special immigrant juvenile, U visa, asylum, VAWA. All of those are exempt, and many of them can and should apply for benefits. Now, all use of cash aid like TAMF or SSI, not just that, but also any state or local cash assistance program can make you inadmissible under the public charge grant. So again, federal, you either are exempted from the public charge or you don't qualify to get it. But the state, that's not the case. Now, a public benefit means any of the following forms of assistance. Let's be specific now. Any of the following on or after February 24, 2020. So again, any federal, state, local, or tribal cash assistance for income maintenance, including SSI, Supplemental Security Income, and TAMF, Temporary Assistance for Needy Families, Housing Choice Voucher Program, Project-Based Rental Assistance, including moderate rehabilitation, subsidized housing, like think Section 8. Now, Medicaid except for the following. So benefits received for an emergency medical condition. Now, services or benefits funded by Medicaid but provided under any of the following. 1. Individuals with Disabilities Education Act. So think of a parent who has a child with autism. Well, that individual gets benefits from school. That individual has doctors and therapists that are paid for by Medicaid. School-based services or benefits provided to individuals of secondary school age, meaning up to high school. Benefits received by an immigrant under 21 years of age. So minor, the immigrant who's under 21. Benefits received by a woman during pregnancy or during the 60-day period beginning on the last day of the pregnancy. So up to 60 days after pregnancy. So again, if you receive Medicaid benefits, but they're under the IDA from school, you're under 21, or you are pregnant, those are exempted and will not disqualify you. So thank you very much for listening to us. Listen, public charge is scary business. It is a big change, but it is a manageable change. It's a function of how you tell your story, and now your story has expanded to how you're a self-sufficient immigrant. My name is Andres Mejer. Thank you for listening. Please, if you have any questions or comments, post them down. Subscribe to our channel. We're here to help. Until next time.